Hey everyone, welcome. Happy 4th of July. Although I don't really enjoy the 4th of July, I usually spend it in bed with animals shaking for hours and hours and hours until the next day when we do it again. And then the next day when we do it again until they run out of fireworks. And man, they buy a lot of fireworks. But hey, what can you do? Once upon a time I celebrated. But cool thing, check this out. Can you see it? Oh, don't judge me unless you're Judge Dad. How cute is that? So I had to make a sample one with what I had around the house just to see what it looked like, and I liked it. So I uploaded the design to the store, and since everybody was having trouble finding it last time, I pinned a link at the top of the chat for you because Judge Dad shirt, wow. So the case we are going to look at today is kind of crazy. It's got like a little bit of everything, but I do want to say that it is a possible trigger for some people. It could be, I don't know. I don't know what people's triggers are. The POS that is being sentenced is charged with heinous crimes that involve his daughter. However, those crimes are not discussed in details. There's very minimal discussion about what happened at all. And the amazing little girl gets on the stand, and you have to hear it to see it. Like, unbelievable. And then what he did to try and cover up the crime, and his brother helped him. And then there's this huge debate over whether that crime can be used as part of the sentencing. So there's a whole lot going on. So I'm going to shut up and I'm going to say good morning, although it's afternoon. And last thing, if you click on the store, the shop link, I pinned it at the top of the chat, and you find a design. If you click on that design, it's available in a bunch of different things. There's short sleeve shirt, long sleeve shirt, men's, women's, glasses, stickers. I think there's cups, tumblers, and I can add more stuff. If there's something anybody wants, let me know. And I'm trying to figure out how to run a discount so you guys can get it like at my cost. So let me know. So this is actually Judge David Wolf, who I think we might have seen once before. He's in Dixon County, Tennessee. And at first I thought he was kind of a country boy, but no, he's pretty straight-laced.
And Mr. Lockhart's motion. So let's bring out the defendant, please. I would also remind everyone that the district attorney has talked with the victim and the victim's family, and that they have requested that this matter be live streamed on the YouTube channel that we maintain. And we're doing that with the agreement that there will be no mention of the child's full name, and that the victims will be identified by the initials LU. Anyone who refers to the child needs to refer to the child in that fashion. The child will not.
So the court wasn't going to live stream it. The family pushed to have this live streamed, and the court said, okay, we will, but we're going to use her initials. Everybody say good afternoon to John, and he's going to have a stream later tonight, so make sure you check it out over at J. Robine Law. I'm sure most of you are subscribed already. If not, you need to.
Shown on camera if she chooses to give any sort of statement. So, all right, this is the sentencing hearing, so let's proceed, Mr. Brooks.
Your Honor, by agreement of both counsel, we will agree to waive any authentication of the pre-sentence report and have that entered as Exhibit 1.
Right. I have a copy here in the file that was filed. Do you want to use that as your exhibit?
That's fine, Your Honor.
All right, we will mark this as Exhibit 1 for this hearing. And you may call your next witness.
Your Honor, I'll first be calling our victim, L.U. She will read a statement, and then I will have a couple of follow-up questions for her.
Right, we need to stop the camera on this.
And if all other witnesses are going to testify, if y'all could please step out of the courtroom.
Rule has been called for, so all witnesses who are going to testify must go outside of the courtroom and remain outside of the courtroom until you're called to testify yourself. You're not to discuss the testimony of any other person until you yourself have testified. Counsel are under a continuing duty to ensure that the rule is complied with. This, if you will raise your right hand and be placed under oath. Is this a victim statement or actual testimony?
There will be a couple of questions.
Thank you. Raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you, ma'am. Just have a seat right there. Can I ask you to speak?
Glad you made it.
Pull that microphone base towards you so that you're close enough to be able to, we can hear you clearly, okay? Mr. Brooks?
Can you please state your initials?
L.U.
Okay. And are you the same L.U. that testified previously at trial in this matter?
Yes, sir.
Okay. Miss Yu. Do you have an uncle?
Yes, sir.
Who is your uncle?
Ricky Yule.
Okay. And you stay in contact with Mr. Yule?
No, sir.
Okay. Are you Facebook friends with Mr. Yule?
No, sir.
Okay. Have you ever sent any messages via Facebook Messenger to Ricky Yule?
No, sir.
Okay. Have you ever sent any messages to Ricky Yule?
Thank you so much.
Admitting to lying on the stand?
No, sir.
Your Honor, I thought I'd move to strike that motion.
You haven't, you just asked for it to be continued in order to allow you to investigate the basis of that motion, and we did that.
I'd move to strike the motion. I do not intend.
Motion, is there another relevance to this proceeding?
It is to the new crime that's alleged, Your Honor.
So I'm going to object to evidence of a new crime.
Yes, just to reiterate real quick, it is a child case. The child gives an unbelievably brave victim impact statement. There's minimal testimony about what happened, and it is hard. It is not bad at all. So trigger warning, yes, but it is very minimal as far as these cases go and what is talked about. The word breast is the only thing that is said. The focus of almost all of this is this fabricated evidence.
Sentencing factors refer to previous criminal history, not to subsequent criminal history.
Your Honor, it does not specify whether it's prior to the act or prior to sentencing, so I would argue that it is extremely relevant for a consideration for the court to make in its sentencing. It's very common for the prosecution to admit evidence of jail assaults or anything, any criminal offense that happens in jail. It's a common occurrence to admit proof of that in sentencing when asking for an enhanced sentence.
So this all makes sense in a few minutes when they start talking about it. But basically what happened was there was an incident where he asked his brother to fabricate this evidence, and it came out that that happened because his dumbass did it on the recorded jail line. So they have this bad act that he did, but they haven't charged him for it. He wasn't convicted for it, but they're sentencing him for this crime, and the prosecution wants to use that as an enhancement factor to get him more time in the window of, the sentencing, and the defense is arguing against being able to use that. So it's a little law nerdy, and then it gets a little interesting with the testimony of the brother, and then we get a little law nerdy again.
Let me have a moment to look at the statute. Are you proceeding under the enhancement factors, Mr. Brooks? Is that what you're introducing this evidence as?
Yes, Your Honor.
I trimmed
And are
out
you
so much dead
proposing
air.
that this is, under which of those enhancement factors are you proposing to introduce this?
I'm proposing to introduce this, but
Crazy.
the sentencing factor that I originally filed with the court was factor one, the defendant has previous history of criminal behavior in addition to those necessary to establish the appropriate range. And the state would argue that this is behavior, so it's not necessary that we have a conviction, and that this is prior to sentencing, which would be appropriate under that factor.
Well, this is a fairly significant issue. It is brought about because of the defense filing a motion for extraordinary relief from bond, alleging that there was a communication on Facebook between this victim and an uncle or a brother to the defendant that purported to allege that she had lied under oath in the trial. And we had a hearing, the prior date for the sentencing hearing was some time ago, and it was reset for today because Mr. Lockhart, who had filed the motion, was later advised that perhaps that was not accurate, and to his credit, wanted to investigate it, and today has moved to strike it. So what I want to do is to ensure that whether or not this is admissible under that rule, I'm going to take a short recess and try to do a little bit of research. If anybody has a case law that you want to propose, then we'll be in recess for a few minutes to let me look at the relevant statute and the relevant case law, and then we'll come back to it. So.
Okay, he said a few minutes. They were in recess for over an hour while they were researching case law. And I just want to say, when I hit 10K, free Judge Dad shirts, I will give away, how much do they cost? 2 free Judge Dad shirts when we hit 10K. So help me out, guys.
We'll stand in recess.
All rise.
All right. I have done some research on my own, trying to determine exactly what the law is on this point. And I've found information that I'm going to share with you that, in my opinion, is relevant to these questions. Number one, the court has granted, or this court will be granted, significant discretion in setting a punishment or sentence in this case. Our Supreme Court has made it very clear, along with our other Court of Appeals, Court of Criminal Appeals decisions, that trial court can consider a lot of different factors. One of the cases that I'm referring to and relying upon is the State versus Winfield, which is a 23 Southwest 3rd 279, a 2000 decision of our Tennessee Supreme Court. In that case, the objection was to the court considering facts of a charge for which a person had been tried and acquitted. And the Supreme Court said that they did not find that the 6th and 14th Amendments prohibited the sentencing court from considering prior criminal behavior for which there's been no conviction. And he goes on to state that we believe by allowing the sentencing court to consider facts underlying a charge for which there has been an acquittal is also consistent with the overall statutory scheme under the Criminal Sentencing Reform Act of 1989. Goes on to state that with regard to enhancement factors, we've observed the statute requires only that they be appropriate for the offense and not themselves essential elements of the offense. The act does not preclude consideration of facts proven by a preponderance of the evidence, even when the facts are the basis for a charge for which there's been an acquittal. Accordingly, we hold the sentencing court may apply an enhancement factor based upon facts underlying offense for which the defendant has been acquitted, so long as the facts have been established in the record by a preponderance of the evidence.
So you say that's on point, but they're talking about something that they've been acquitted of. In this one, hasn't even been charged with it. So,
State
hear the other
versus
side
Winfield.
first.
that's been upheld or followed in a
Hey,
recent
Tommy.
case, State versus Howard. It's an unreported case from the Court of Criminal Appeals in 2017, which basically goes on to say that Winfield decision does not prohibit, the act does not prohibit or preclude consideration of facts proven by preponderance of the evidence, even when the facts are the basis for a charge for which there's been an acquittal. Clearly, an uncharged, and then there's multiple cases where the court has upheld the sentencing consideration, or the court considering it sentencing, the acts proven that were uncharged criminal offenses. So the really only question becomes whether or not this bringing in this information because of the fact, does it constitute prior criminal behavior? Until I hear that evidence, I can't make that determination. So I'm going to overrule Mr. Lochran's objection, allow the evidence to come in. I will then consider whether or not this evidence is or is not, or it does or does not fit the category of prior criminal behavior enhancement number 1 under the statute. But until I hear that evidence, I can't make that determination. So Mr. Lockhart, your objection is overruled. I will decide whether or not it fits that at the sentencing, according to the sentencing guidelines, and I'll either apply it or not apply it, depending on how I find.
And I assume we'll be able to be heard at that time.
I'm sorry?
I
Yes, you will
assume we'll be able to be heard at that time.
Yes, I'm not precluding you from arguing. I'm just simply saying, I know what the evidence is at this point, the state is trying to present. Number one, I haven't heard anything that actually determines that it was criminal behavior by your client.
Yes, Your
So
Honor.
this is going to have to be proven by the state so that I may determine whether or not he is engaged in that conduct or some other person has. And if some other person engaged in it, then it would not be attributable to your client. So I've got to hear the evidence, make the determination then of whether it fits in, but I'm not precluding you from being able to hear it. All right, Mr. Brooks, if you want to call Ms. L.U. back to the stand.
Ms. Yu, if you flip to the, what appears to be messages on that behind that motion, if you look in the lower right-hand corner, they're labeled 2 out of 8 all the way to 5. Do you see those numbers? That's the bottom right, okay. Now, referring to page 2, you see that?
Let it be.
Yes. Do you recognize that message?
No, sir.
Did you ever send that message?
No, sir.
Okay. If you can turn to the next message. And what is the number in the lower right-hand corner? 4. Is that a message or is that a post?
I think it's a post.
Okay. If you can.
But no, it's a message.
It's a message? Okay. Did you send that message to anybody?
No, sir.
Okay. If you could.
I know she sounds like she's like 5 years old, but she was 12 years old at the time of the incident, and I'm not sure how long ago that was. So she is older than that. She just has a tiny little voice, but damn, she's awesome.
Flip to the last message. What is that message numbered?
5.
5, all right. And did you send that message?
No, sir.
Okay. Your Honor, I would ask that that be made an exhibit. It is a certified copy of Mr. Lockhart's motion that he has already filed with the court.
All right, mark it as exhibit 1 to this hearing. 2, I'm sorry, yes.
Your Honor,
This is
would it
the
be
sentencing
appropriate-
hearing.
I'm through my questioning. The witness would like to read a
A little
statement. Would
wacky.
it be appropriate to allow Mr. Lockhart to have an opportunity to cross
Allow Mr.
examine?
Lockhart cross-examination if he chooses.
He's been found
and we'll
guilty.
allow her to read her victim impact statement.
Of course.
No
Thank you.
questions.
All right, then we're ready for her to go ahead and make her victim impact statement.
Ms. Hsu, did you write out a statement for the court?
For him?
Yes, correct.
Yes, sir.
All right, would you like to read it?
Yes, sir.
This is his daughter.
You have the floor.
Do I have to stand up?
You don't have to stand.
Okay.
But listen to this. Unbelievable.
Jimmy, the things you've done, they hurt me every time I remember something. You've really traumatized me. I don't trust other people. I'm scared, and that's because of you. You tried breaking in my window. You killed my cat. You stayed in my papa's back 40s in the old car. You hurt Wyatt. How could you? You were supposed to love us and be there for us and not hurt us. You can't be a father or dad if you can beat and molest your kids. You can't tell us that you love us because you don't. If you did, you wouldn't have done the things you've done, and there's no going back. But just because you're going to prison, don't give up. There's still good out there for you. When you get out, you just need to get the help you need and be a better person. And if you do become a better person for yourself, I don't want you running and trying to talk to me just because you want to, or you feel sorry because you don't need to. I don't, and I never will need you in my life. I'm better off without you, and you're better off without me. I'll forgive you someday, but when I do, I still won't talk to you. You've never known anything about me other than I was obsessed with horses. You don't have the right to get to know me. I don't want you to know me. Ever. Whatsoever. I wouldn't have or know what to say to you. You gotta do better. Please do better and find yourself while you've got the chance to and time to. I'm sorry it had to go like this. I did give you a really good plea though. You could have took that, but you chose to do it the harder way. I'm only sorry because you got to spend some time, but you do the crime, you do the time, and you did a crime. I hope that you take this time and think about everything you've done, and if you feel it's a mistake, learn something from it, stop doing it, please. You still have people waiting for you when you get out, like Nana and Ricky. I don't know if I'm happy or sad about this. You're going away. You're going far away, locked up. Good, you'll be far away, so I won't have to worry. I want to come one time and see you, so I fully know that you can't hurt me or anyone else anymore. It's time for me to say goodbye now because I think I've said everything I needed. Goodbye.
Is that all? Thank you.
Yes, that's freaking all. What the hell? He didn't mean it that way. I know he didn't, but damn. Wow. Okay, now do you guys understand? Like, I don't like this subject matter, but man, that girl. Everything she's been through, and she gets up there and has compassion for that piece of shit sitting at that table. This is Dixon County, Tennessee. And I just wanted to point out, look in the courtroom and see the tie-dye behind him. That is the one person, that is his mother. She said, you know, you still have Nana, that's his mom. And Ricky is the brother who we're gonna hear testify in a few minutes. That's the interesting part. But what an amazing young lady. Wow. I know adults who couldn't get up there and talk like that after what she's been through.
So much, Miss you. Or miss you return.
All right, you may step down. Thank you.
Oh, I'll get kicked off of YouTube for
Brooke,
that.
you may call your next witness.
Yes, but they don't talk about it in details. It's very,
State would call Brittany Loveless with mental
some
health
details, but
cooperative.
very surface, and it's not graphic.
Be out in the hall.
Hell yeah. I know, right? Like, I want to send the little girl a shirt and be like,
Please, ma'am.
fucking awesome. I wouldn't be the
I
thing
ask you
to
to raise
send
your
her,
right hand
but
and
something.
place your
I don't know. I just,
Do you
I have no idea who
solemnly
she
swear or
is,
affirm
but
that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God. I do.
Just as a reminder, since it's been a long time, we are referring to the victim by her initials, LU.
yes, sir.
Right. Can you please state your name for the record?
Brittany Lovelace,
And
The
where are you
case might
employed?
have,
Mental Health Cooperative.
And how
the
long have you
sentencing
been
was
with
just a
the
couple
Mental
days
Health
ago.
Cooperative?
This time 4.5 years.
Okay.
I've worked there twice, sorry.
And what is your position there?
Case manager.
And have you occupied that position the entirety of that time?
Yes, sir.
Okay. And describe what a case manager does.
We collaborate with our.
I'm going to disagree with that because this child has been in therapy for multiple years, and a lot of those things she said are CBT, DMT type things. So I think she was using what she learned in therapy to let go and move on with that letter. My opinion, but we can disagree.
Med provider, therapist, to get, or any outside sources to get I'm a kids case manager, so we collaborate to get them the help they need to overcome any emotional, mental health, behavioral health, academic or physical health goals.
Okay. And are you don't have anything to do with actual therapy or diagnosis, correct?
No, sir.
Okay. But can you detail a patient's treatment through your company?
Yes, typically, once they come into services, they will meet with their med provider where they have a psych evaluation. That is when they get the diagnosis and will discuss any medicine that is needed. And if needed, they will also start therapy and come in and work with a therapist to overcome whatever the symptom or behavior is.
Okay. And are you familiar with the young lady that stepped off the stand, LU?
Yes, sir.
Okay. Is she a patient at the Mental Health Cooperative currently?
Yes, sir.
Okay. And when did she begin treatment with your company?
With me, I started back in January of 2019, and that's when I started working with her. I do not have the exact date. I meant to get that before I come. I apologize. But she was already in services when I come to work there.
Okay. If I handed you up some notes, would that refresh your memory?
Yes, sir. Yes.
Your approach.
Yes. So our system, when I got this together for you, goes back to 2018 because I started in 2019. We were using a other program prior to that, and this goes back to when she started in 2018 with us, therapy.
Okay. And what kind of treatment has she done with the Mental Health Cooperative since
Objection.
2018?
It's my life.
Unless he has the medical and psychological experts here to testify, I'll object to her as a case manager discussing her treatment, prognosis, diagnosis, anything of that nature.
She's not here to discuss
That's her
any
job,
diagnoses, Your Honor.
coordinate
She's
it
just here
all.
to detail treatment received through her.
I think there's a difference between her just relating what the records reflect as the treatment received versus a diagnosis or a professional opinion. So she will be limited to giving only what the records reflect as to the type of treatment she's received. She will not be allowed to give any professional
Did I say
opinion or render any kind of diagnosis. So sustain the objection to that extent, but I'll allow her to testify as to the records.
And since 2018, what treatment has you received through the Mental Health Cooperative?
Therapy, case management, and med management.
Okay. And can you describe those functions?
Therapy, going back to like what I had said before, working with a therapist to overcome any symptoms or behaviors, med management as well, kind of with the same, and then case management, collaborating care for the therapy, med management, and working to reach goals.
And is this treatment in regards to the sexual assault allegations that occurred prior to 2018?
I don't know that I can answer that. I don't know if that would be like an opinion base, but that has been a concern that has been worked on in all three of those areas, if that
Okay.
answers your question.
Can you describe the other phases?
Are you talking about what's on this list?
Yes, correct.
She also was in intensive services with us, and that is more of like a therapeutic case management where they meet 3 times weekly. And so like she also did that with us. And at 2 different times she was discharged from us when she had went inpatient at a different place from us.
Okay. And does she continue to seek treatment through the mental health cooperative?
Yes.
Okay. That's all I have to witness, Your Honor.
Clark, do you have any questions?
No questions, Your Honor.
Thank you, ma'am. You may step down. We're releasing you from your subpoena, and you may go, you can stay or go as you choose. Clerk, you may call your next witness.
State would next call Lieutenant Heather Hoope.
Heather walks
Who
slow.
bay?
For those of you who came in late, don't forget the new Judge Dad shirt
HUPE.
is in the merch store. Check it out. Don't judge me. Unless you're Judge Dad.
You'll step right up, please, and raise your right hand.
solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Can you please state your name for the record?
Lieutenant Heather Hoope,
Ms. Hoope, where are you employed?
Dixon County Jail.
And what is your position?
I'm the lieutenant and the security officer.
Okay, and what are some of your functions as a security officer?
I deal with all of deboard process, any safety and security issues inside the facility, phone calls, text messages, videos.
So when you refer to phone calls, what do you mean?
All the phones that are recorded inside of the facility, I am the one that investigates any phone calls in there. Anytime that there's a recorded needed, I'm the one that has to handle all those.
So how does, if somebody is housed in your jail, are they able to make phone calls?
Yes.
Okay, how are they able to make phone calls?
Inside their pods, they have 3 phones that hang on the wall that they're able to access at all times of the day.
And are you referring to the inmates?
Correct.
Okay, does this require any funds?
It does. In booking, when they first come in, that those phones are free. But inside the pods, the family has to put money onto the phones for them to be able to use.
Right, and does each inmate have a particular ID that they have to use in order to use these phones?
They do. When they all come into the facility, there's a jacket number that is added to their ISOMs when they first come in, and that's the number that they use. And they also make up a PIN, which I believe is the last 4 of their social.
Is it common practice for inmates to use other inmates' IDs or accounts to initiate phone calls?
Yes.
Okay.
Imagine the shit she hears on a daily basis. Like having to like monitor the jail calls. I can't even imagine the stuff she would hear. And I don't even know if I want to know. Like there's some things in life I can just keep on going and yep, nope, I'm good. Thanks. Hey, beach lover, welcome.
So when a phone call is made, what is does it announce itself to the recipient in any certain way?
It does. It comes across as a recording stating that there's a phone call made from this specific inmate where they say their name. And then it tells them that this call has been recorded, and it goes through a whole little verbiage of what the phone system is. And then it tells you have to press a certain number for it to be accepted.
Right.
We still use quarters? Not everything
Your
is
Honor, we
digital these
have
days.
no objection to, of course, reserving my standing objection to the admissibility in this sentencing hearing. We have no objection to these calls being played. The district attorney has provided them to me. I've heard the calls, and the simple way would be just to allow them to play those for the
All
court.
right, We'll allow them to be played.
So in case you can't tell, they're laying butt to butt with their heads on the floor.
Just for identification purposes, do you recognize those CDs?
Yes, I do.
Okay. Have you been able to review those CDs?
Yes, I have.
Okay. And are they phone calls made from the Sheriff's Department jail services?
Yes, ma'am.
Your Honor, I'd ask that those be made an exhibit, and then I would ask that you publish those.
Fine. Welcome as the collective exhibit, which would be 3.
I should do that. I should start a swear jar.
Your Honor, for the YouTube
Probably make more
sake,
money from myself than anybody
you
else.
mentioned
Oh,
one
no,
of the
John, I'd
inmates
make more money from
mentioned
John.
the victim's name, so I'd ask Ms. McKinney to not publish this to YouTube.
Are you going to let us know which one it is?
I know it's at least the first one.
The first one, so we're going to mute the live stream for this recording.
So they say her name out loud in the jail phone calls where this
If you step
incident is
around
actually
where the officer is,
discussed.
Please.
So there was about 35 minutes worth of phone calls, 3 different phone calls that I had to edit out. They left the cameras running, but it was just them sitting there listening to phone calls that we couldn't hear. So we really have no idea what he actually said during the phone call, but this is his brother, Ricky.
I'm going to ask you to the best of your ability, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Griggsy, I just downloaded 21 hours worth of body cam footage for a case I wanted to look at.
Yule, in regards to referring to our victim, we're only using her initials, okay? So we will refer to her as L.U.
Not fun.
Yes, sir.
Can you please
Oh,
state your name?
Iris.
Ricky Yule.
Mr. Yule, you have appointed counsel on this matter?
Yes, he's.
And has he fully advised you of your Fifth Amendment rights?
Yes.
And are you willing to waive those today to speak?
Yes, sir.
All right. Isn't it true that you have a pending tampering case?
Yes.
All right, and you are currently in jail on that, correct? All right. Have we worked out any type of agreement as of yet?
I don't know yet.
Your testimony today, is it possibly to facilitate you getting out?
Oh, okay. I didn't know.
Do we have an agreement to that effect?
I wasn't for sure, but yeah.
Okay, so your testimony here today, you have motivations to get out, right?
Yeah, yeah.
Just to lay it out in front of the court, okay?
He doesn't seem to know what's going on or why or how. He has a plea deal to be released if he testifies, but he just has no idea why he's there, it seems like.
Do you know the defendant, Jimmy Yule?
Sir.
And who is he to you?
Brother.
All right, can you point him out and describe where he's sitting? Where is he sitting? I mean, could you verbalize it?
Right there.
We're not going to keep doing this. There is a rule with YouTube. If you have a video and you're playing it on your channel and you didn't create it, you have to provide commentary. Otherwise, they will shut your channel down. So if you don't like it, go find the original yourself and watch it. I'm so tired of the you talk too much stuff. Like, I don't have a choice. It's a commentary channel. Like, fuck off.
I guess his lawyer.
Okay, and what is he wearing?
Iris, can you add another
Your
5
Honor,
swear
for
jar
the
for
record to
me?
reflect the
Thanks.
witness.
Witness
Just
has
kidding, don't do
identified
that.
the defendant.
Okay. Does Jimmy make phone calls to you from the jail?
Yes, sir.
All right. Does he always call from his account?
Yeah,
Okay.
that's
All
probably a
right.
good idea.
Do you know why we're here today? Okay.
Oh, yes, sir.
You know why we're here? Has he ever instructed you, you know the phone calls were here in question?
Yes.
Okay. Did he call you on April 25th of this year?
Yes.
Okay. What was the contents of that of that discussion you had with Jimmy on the 25th?
He was wanting me to make a fake profile for LU, and like an idiot, I did.
Okay. What was the purpose of making that fake profile?
He said to kind of show that that she was lying or something, but trying to make it look like it or something.
You're referring to the victim LU?
Yes, ma'am. I mean, sir. Yes, sir.
Okay.
I'm sorry, I'm nervous.
Your Honor, can the defendant be passed Exhibit 2?
That's why I kind of wish we would have heard what he said to him. Like, how much did he tell him to do and how much did he figure out on his own?
Can you flip through those pages?
Great. Thank you. Welcome, welcome. Mm-hmm. To be fair, I mean, his brother made him do something pretty crappy.
Do you recognize what was handed to you?
Yes, sir.
Okay, what is it?
Fake profile.
Okay.
Whatever you call it. Yeah.
Okay, so you indicated that it was from a fake profile.
Yes.
Did you create said fake profile? Okay,
Sorry to say it, but
all
yeah.
right. And are these the messages that you handed to the defense attorney to file this motion?
Defense attorney.
Did you hand them to Mr. Walker?
No, I texted him.
Okay, but you handed these messages over to Mr. Walker?
Yes. Yes.
Okay.
Which I shouldn't have done, but
And these are messages that you yourself fabricated to yourself? Did Jimmy call you on June 1st?
around that time, yeah.
What or about? Did he give you any further instruction?
Yes, but to get a Dollar General store phone, try to do some more of that stuff, and I didn't do it.
Okay, so when you say stuff, what are you referring to?
Like, get more damaging or what, something or other, the evidence or something, fake evidence, whatever, but I decided not to do it.
Okay, so you didn't actually act on those instructions on June 1st?
No.
The April 25th instructions you did act on and follow through with?
Yeah.
Okay, and you've since been charged with tampering with evidence?
Yes, sir.
Okay.
Bless his heart.
That's all I have this witness, Your Honor.
Mr. Locker, do you have any questions?
John, check your Twitter.
On the first phone call, you and your brother discussed LU sending messages that she had lied to get her dad in trouble. Ha ha ha. Are you saying that you manufactured all of that?
Thank you.
You created it?
I was an idiot for doing it.
All on your own
All right, that's all the questions I have.
I can't
with no help?
take it back. I wish I could.
All right, thank you. You may stand down and we'll return you to custody. Thank you.
So, did you know that burner phones are now called Dollar General phones? Number one. And messages through Facebook are called fake profiles. So what he did was he created a fake Facebook profile and then he texted himself or instant Facebook messaged himself. Gosh, we have too many social medias. Can we just condense it down to one? Just one big social media that does everything? So he Facebook messaged himself saying that the daughter LU had lied on the stand. And then he forwarded screenshots or something of those to the defense attorney. And I picture him as the guy that sits there sticking his finger in the chocolate fountain. Like he's the reason I don't go to Golden Corral. Just saying. Just WTF. Hey. The father is the one, he's been convicted.
Take the
And
last
then
call, Detective Lovell.
that's the brother. The father called the brother from the jail phone and told him to create those messages, the fake profile, and send the messages to himself to say she lied to try and get him out of trouble.
No truth, nothing but the truth, so help you God.
Piece of trash.
Can you please state
No,
your
real
name for the
children,
record?
from what I could tell.
Jeff Lovell.
And where are you employed?
I'm a detective with the Dixon County Sheriff's Office.
And what is your position?
Detective,
And
yes.
how long have you been in that capacity?
In that capacity for almost 10 years.
And were you working in that capacity on or about April to June of this year?
Yes, sir.
All right. Were you made aware of some suspicious jail calls this
Yes, sir.
year?
I
Okay.
was.
Did you have an opportunity to listen to those as they were played in court?
I did.
Are you familiar with the defendant, Jimmy Yule?
I am.
And are you familiar with Ricky Yule, who just was on the stand?
I am now, yes, sir.
Okay. Have you had opportunity to hear their voices?
I have.
What opportunities have you had to hear their voices?
Over the probably the last 6 years, anytime we've had court proceedings, when I interviewed Jimmy Yule back from the original case, and then once I got the phone calls, I listened to those between him and his brother. The calls we're here on today.
Okay. And while you were in court just now and you're listening to those calls, are you able to identify the speakers in those calls?
Yes, sir.
Who are they?
They're Jimmy Yule and Rick Yule.
And Jimmy Yule, what was his part in those phone calls? Can you just distinguish his voice from the other?
I just know it. You can sometimes you could hear stuff from like inside the pod or whatever, but just the stuff he was saying let you know which was which. Their voices are different.
Okay.
Think about that for a minute. That's a really hard question. Think about your friend. You hear them talk, you recognize their voice. Explain to me why you recognize that voice. Think about that.
And who was doing the instructing?
Jimmy Yule was doing the instructing.
Okay, when I refer to the instructing, I'm talking about the potential fabricating evidence.
Yes, sir. The fake profiles and the dollar store phone, that stuff. Yes, sir.
That's all I have, Your Honor.
Walker, any questions?
No questions.
Thank you, Detective. You may stand down and have a seat. State may call your next witness.
State's approved, Your Honor.
State has rested their proof, Mr. Locker. Do you wish to offer any proof?
I would request a 5-minute recess.
All right, we'll take a recess and
Are dollar store
probably
phones
need 10
$1?
minutes. How about that?
That'd be kind of cool.
Maybe seated.
Yeah, that was like a 20-minute recess. We're always say 5-minute recess, and it's like 4 times that.
Oh, you got one client, so. Go ahead.
Just start tracking it, make a chart. I can't believe how many of you are on here. I thought everybody would be out 4th of July in. All right, I'm gonna do a poll. 4th of July, fun or what's another word? What's the word for, hey, this sucks because I'm stuck in bed with dogs that are shaking? Dramatic.
Mr. Lockett, do you have any proof you wish to offer?
No, Your Honor, I've discussed with my client whether or not he would take the stand or not, and based on my advice, he's choosing not to take the stand and testify, so I have no proof.
I'll hear you an argument then. Mr. Brooks?
Good on him. I hate the 4th of July. These little monsters are gonna be up all night because every little boom they freak out about. And then the cats start.
Your Honor, after a
"Oh,
jury trial, the defendant was convicted of TCA Code 4035, say no. Was convicted of 3913-504, the offense of aggravated sexual battery. The legislator has taken a lot of the decisions out of the court's hands in this type of case. According to TCA 4035-112, this is a B felony. The defendant was convicted as a range 1 offender. There's been no proof to say he's a higher range, so he would be sentenced as a range 1 offender. That carries a range of punishment of 8 to 12 years with a maximum fine of $25,000. The defendant is not eligible for probation, subject to TCA Code 4035-303 for the conviction of such offense. This is also a 100% crime. It is to be served at 100% according to 4035-501. So there will be no opportunity of parole except for good time credits that can be achieved at maybe 15% off his sentence. This is a violent sex offense. It is required by TCA Code 3913-524 that it be a community supervision for life. Also, as a violent sex offender, he's be placed on the sex offender registry for life once he's released from incarceration, 4039-202. Really, the only thing to discuss at this stage is...
Yeah, he was offered a plea deal and he refused it. I don't know what the deal is. He's just a piece of garbage. I really wish I could have seen the trial to know what was going on. When this came on the other night and I saw the brother testify and all that, and then I heard the little girl, I was like, what the?
We know he's going to serve. It's really a matter of where he falls within that range of 8 to 12 years. And that's where we go to the mitigating enhancement factors. And the state has already pre-filed a notice of enhancement factors we intended to approve today, and that's what I'll argue right now. Factor 1, the defendant has a previous history of criminal behavior in addition to those necessary to establish the appropriate range. The defendant, looking at his pre-sentence report, he did not have much of a criminal history, if at all, prior to these acts. However, during these, while sentencing has been pending, he has committed serious felonies. The state has provided proof today that the offense of C felony tampering with evidence has been committed, and also an attempt to fabricate more evidence on a second occasion. On April 25th, he called his brother from a separate account. He instructed his brother to create a fake Facebook account and to send messages from said Facebook account to essentially insinuate that the victim was lying at trial. And the court and the defense, we all know that would be a serious consideration for a new trial if in fact the victim had sent those messages. In the process, the defendant has made a mockery of this court, has made a mockery of his counsel's representation. He has made a mockery of this case to our victim. And the state would ask that the court would consider strongly those acts while the sentencing hearing has been pending. Factor 4, the victim of the offense was particularly vulnerable because of age. The victim, LU, was 12 years old at the time of this sexual assault. That is when innocence is very important to our children. And that was severely infringed upon when this act was committed. Factor 5, the defendant treated or allowed the victim to be treated with exceptional cruelty during the commission of the offense. The state would submit that the fact that a biological father would subject his biological daughter to sexual assault in and of itself is exceptionally
I will let
cruel.
the judge finish, and then I will go on a rant if Meg allows me to.
Okay, let him finish his.
That would go into violating the position of trust, public or private. In factor 14, I'm sure, I would assume that Miss Yu had great trust with her father before this. And that's how, and that led to how this act was committed. At trial, the victim testified that she was sleeping in her parents' room, in the floor.
Okay, this is the only time they really talk about what is going on. And like I said, it's very mellow compared to what normally is said, which is very graphic and everything else. But I just want to FYI in case it bothers anybody.
No, that's
Imagine
that's
she had to
fair
have a
to
great deal of trust to be able to go to sleep at night in her parents' room. I assume a lot of children do. And then she wakes up to being fondled by her father. Her father's excuse was, it was a mistake. I must have mistaken her for my wife.
Just process that for a minute. Oh, I thought it was my wife as she's sleeping on the floor.
No, that's absolute bullshit.
And the mandatory sentence is 8 to 12 years.
That is far too
Just line
lenient.
them up for me.
As far as I'm concerned,
No,
that
it's all-
should be an executable offense.
That his daughter was sleeping on the floor, not in the bed.
Mm-hmm.
Factor 6, the personal injuries inflicted upon the victim were particularly great. Ms. Lovis from the Mental Health Cooperative, she was not able to testify to the actual diagnoses per se, but she's able to detail the extensive treatment that LU has received since these events, and she continues to receive them. The defendant may be serving an indefinite sentence, but the victim will likely have to live with this the rest of her life. And to her credit, she takes the stand and reads her statement and irregardless of what atrocious offenses have occurred to her, she shows empathy. She states, there's still good out there for you. And I hope when you get released, you go back to the people that are waiting on you. Speaks volumes of her. And on the flip side, while this sentencing hearing is pending, he's trying to fabricate evidence. Two different sides of the coin. Speaks volumes to Miss You and the person she is.
Agreed.
The offense
He doesn't
involved
deserve.
a victim who was committed to gratify the defendant's desire for pleasure or excitement. Like there's no question that when dealing with sexual battery, it's to involve to gratify the defendant's desire for pleasure or excitement. The state would submit that the only appropriate sentence is to sentence him to the maximum range of 12 years in that 8 to 12
That's old.
TDOC. Thank you.
Mandatory.
That should be death. Sorry, I know that you have a lighter channel than I do, but in my opinion, that should be a death sentence.
Florida's tightened up their laws, but most states, the laws for offenses like that are not. To be fair, in the overall scheme of things, what I'm understanding he was accused of, the extent of it was he was laying on the floor and he had his hand on her breast. So
Okay, and
I am not saying that he's a piece of shit and needs to be taken out to the wood chipper, like they said. I'm just saying that
I would prefer that you not be part of society for the rest of your natural life, at the very least.
absolutely, but I think there's another level it can go to. I don't really want to get into that discussion because there's lots of words that I don't want to say, but I think that
And we don't have to.
it's unnecessarily categorized by the physicality of the action.
And so maybe it was not prurient in nature. It was
Yes, there you go.
a drunk individual who happened to hold his daughter in a certain way.
Yeah. But she did mention in her speech other abuse and things like
I
that.
I know that, and that's why I have a problem with it. Like, if it were just, somebody came home drunk and happened to, big spoon,
On the floor instead of in the bed with your wife.
it's not good, but, it's not
Yeah.
necessarily to the extent of
But I think
death.
if you were the type of person that was drunk and did that on accident, you wouldn't be trying to get someone to manufacture evidence to get you off.
No, generally speaking, not.
Yeah. So
Um,
the
I think we're kind of on the
defen-
same page here.
the defense's argument absolutely infuriates me because I understand that everyone deserves a solid defense.
Yes.
But in my mind, a defense attorney's job used to, way back in the day, be to protect the defendant from being wrongly treated or wrongly accused by the prosecution, to make sure that they are treated fairly and their rights are upheld. And way
Yes.
back,
Yes and no. Because way back when we're talking about the American justice system, we're talking about the British justice system.
but I'm not
And,
going that far back.
well, how far
But-
back would you like to go?
Some people say that the change came with OJ,
No, it did not.
that's
It happened
when
long
this
before that.
overzealous representation, I can buy my way out of anything, but it kind of trickles down. I just have a problem when I see a defense attorney that is
Bill Rhodes is absolutely right. Magna Carta is pretty much when the legal system shifted gears.
but he's going up there. He knows his client's guilty.
Yes.
And he knows that he needs to put on a defense for him, but he's
Yes.
attacking the victim. He's
Maybe that's your
twisting the
best.
truth.
Maybe that's your best defense.
But that should not happen.
We've talked about this before. The first writing assignment that I was given in law school was a hypothetical. You know your client is guilty. Can you still defend them? And if your answer was no, you were generally told law is not for you.
I can absolutely defend them. But there's a difference between defending them and this overzealous attacking everybody, trying to find loopholes in the law. I'm defending them and I'm making sure that they're treated fairly and everything else. Like, a defense attorney's job shouldn't be, hey, can I screw the system to get this guy off when I know he's guilty?
Yes, that is literally your job.
But that it shouldn't be, and it was never intended to be. It was always intended to be a protector position, protect his rights because he doesn't know the law, and you're making sure the law is followed on his behalf.
Here's where you and I think, are diverging. And the reality is that at that time, a defense attorney's role was to go against the crown. So you had to have all of the powers that you could bring to bear as against the crown. Now that we have changed our societies somewhat over the last couple hundred years, it's a little bit different, I suppose. But the job of a defense attorney is still and always will be to fundamentally protect the interests of their clients, period.
Absolutely. And I think that protecting the interest of the client means making sure that the law is followed, not twisting the law and almost breaking it, which is what we've pretty much come to in so many of these cases.
I don't know that I necessarily agree with you. Willie, we can continue. I'm going to find a case that identifies the point that I'm trying to make, but we can continue in the meantime.
It just, when you know he's guilty,
First,
why
I'll
would you
address, Your
bash
Honor,
the victim? That just
whether the
it's
court is to
so
consider
dirty.
the evidence in this case of the attempt to solicit or manufacture false evidence or tamper with false evidence. The court cited some cases. The state has provided a case. I would submit those cases all involve prior convictions where a defendant was afforded the due process of a trial, an attorney, an opportunity to defend against those cases. And even in cases where he was acquitted, he still was afforded
The
that due
conversation
process
through
previously.
Robot.
In
I
this
haven't
case, there
wondered.
is no.
You're not allowed to talk over videos. Hard rule.
Sorry. I have the case ready to go when it's appropriate. I will let you
Prior
determine.
conviction. By virtue of the fact that it's an ongoing investigation, it puts the defendant in a position where he's not afforded the due process of defending against those charges. To my knowledge, he's not even charged with those charges yet. I'm sure he will be. One of the considerations in not putting my client on the stand would be the fact that it would be difficult to contest those charges without subjecting him to cross-examination by the state.
Would you mind
That
pausing for
depending
one
on his
moment?
answers might
Mr.
further
Jones,
incriminate him. So I would.
Okay, that's strike number 1.
Fine.
Hard rule.
All right. So
I get in big trouble. No talking over the video.
I think that it's your channel and you can decide when it's appropriate to talk or not. But, you know, if you want to give all of your control over to the peanut gallery, then
we made a deal way back when. We all made a deal. We did pinky promise that I would not talk over videos.
I don't recall that one. I don't think I was part of that contract.
Yeah. So, in order to continue hanging out with us cool people, you got to not talk over the video. All right. Yeah, but it's kind of hard to hear to begin with. And trust me, you're in the minority. I'll get yelled at in the comments. What's up?
No, you told me what the rule was.
I paused it so you could talk. You just have to pause. Pause is okay. Just can't talk while they're talking.
Well, I asked you to pause precisely for that reason. Damn it.
Pause. Somebody tell me what the sign language for pause is.
I don't freaking know. I'm just going to do this from now on.
Okay.
No, I lost it.
Then you should watch it on the trial channel, not the opinion channel. Oh, shit. Who would have
Wait,
thought of that?
That's a really, really interesting concept. I don't know. I think I lost it, but there was somebody in the comments that I really wanted to. Mr. Jones, bashing the victim is as old as time. That's why states have laws against digging into sexual past of SA victims. That is true. It's also very, very likely unconstitutional. These are the R-word shield laws that are probably unconstitutional. I wanted to bring that up.
I just think that in this circumstance.
Oh no, I have no problem with how they're handling in this circumstance.
No, but when he's, saying the victim didn't have any trauma and a couple other things, that it's just so.
Well, we heard her
cool.
testimony. So, now it's just a matter of weight of evidence.
Submit. That evidence should not be considered because all the cases we've looked at, the defendant in those cases, whether he went to trial and was convicted or went to trial and was acquitted, had the opportunity, the due process protections of going to trial.
We do.
Putting on proof, cross-examining witnesses. In this case, he's not even charged yet. Certainly no discovery has been provided in regard to The case, other than the phone calls themselves, to my knowledge, no records have been subpoenaed from Facebook or any real detailed investigation. So my client is not afforded the due process he would have been afforded if he had been charged and had to go to trial on tampering with evidence or conspiracy to tamper with evidence or whatever the charges will end up being. So I submit that kind of hogtied the defendant in a position in this case where he couldn't even take the stand and try to address those because it's a pending investigation. And it would make it difficult for him to take the stand and testify in this case. So I submit that that evidence should not be considered where the defendant is not afforded at least a chance for a jury to either convict or acquit,
That argument.
and where he's afforded some due process in regard to defending against those charges. So I would ask that not be considered in regard to enhancement factor. Number one, I would submit that if you set that aside, he has no criminal history that would cause him to be enhanced at all. The fourth factor, the victim's age, I submit, is an element of and inherent in the offense itself. So should not be considered by the court.
The actual offense he was charged with, I had originally done this with notes on the screen, is whatever with a victim under the age of 16. So that's why he's arguing it's inherent in the charge
fifth
itself.
Factor, I'd submit there's been no showing of exceptional cruelty. Other than that, that would be inherent in the offense itself of aggravated sexual battery. The case manager testified that LU was being treated, but couldn't even say it was solely for this. She said that would only be an opinion. So we don't even know what all she's being treated for. But I submit there is no showing of exceptional cruelty other than that which is inherent in the offense itself. Also, number 6, I submit there's been no showing of great personal injuries. Perhaps the state could have put on proof of a medical expert or psychologist, but there's been no showing of great personal injuries to LU. Number 7 enhancement factor I submit is inherent and an element of the offense and therefore should not be considered. Number 14, there's been no showing that the defendant requested LU to come sleep in the bedroom. No showing that he used a position of public trust to facilitate the commission of that crime, which has to be.
Those last two, I think, are absolutely valid.
So I submit that should not be.
What was that?
Those last two, I think, are absolutely valid. They're throwing the entire book at him, but it doesn't necessarily apply.
Considered either. In regard to mitigating factors, I would submit.
I'm not saying that I don't think the guy's a bad dude.
That
I want to be clear about that. I think that he should go away for a very long time. I said execution. Just so we're clear. I mean, if you harm a child, I think that you should die. But the argument that the lawyer is making is not terrible in terms of trying to remove escalation factors.
Yeah, that's why this kind of got me. I mean, there are really good legal arguments, both sides, and then the judge over explains everything.
The criminal conduct neither caused nor threatened serious bodily injury. Number 3, that substantial grounds exist tending to excuse the criminal conduct based on the defendant's statement to law enforcement that it was an accident, and as soon as he realized his hand was over her breast, he removed it. Number 11, that under those circumstances that it was unlikely that a sustained intent to violate the law
That's true.
motivated his conduct. And number 13, any other factor which I would request the court to consider the lack of previous criminal history and also the defendant's work history as reflected in the pre-sentence report. So I would request that his sentence be 8 years.
So he's requesting that it be
Any further
the
remarks?
deadline.
No, Your Honor.
This whole entire hearing is basically over 4 years.
Whether it's 8 or 12.
Yeah, whether it's 8 or 12, this whole freaking thing, all this drama is over 8 or 12.
Well, again, like I said, I think he should be executed. But,
Yeah.
unfortunately, my view does not actually hold sway in society generally.
No, and honestly, you can tell by the judge, he's not super happy having to deal with all this.
I think the judge would be very happy to give him a life sentence.
Yeah, he's looked very uncomfortable multiple times.
So,
But
it is what it is.
yeah, first what he does is goes into a big long explanation about why he has to follow the 8 to 12.
Well, and so before you restart that, I want to say the defense attorney did the best job you could possibly do given the circumstances that were afforded you. So
He did. It just I don't
I
like
have
when
nothing, I have nothing
disrespect-
against the defense attorney.
when you're disrespecting the victim like that, it just really bothers me.
But you
When
sort
it's a
of,
child.
you sort of have to in order to try and get one of the enhancement factors off the table. I get why he did it. I don't like that he did it, but I get why that was part of his professional obligation. I don't know. Maybe that's not it.
Court is required to follow the state statutes regarding sentencing that's to be imposed, and those are set forth in the Tennessee Code in Section 4035-103, which are the sentencing considerations. And for the record, so that there's no question about my considering and following all of those considerations, I want to go through them. Number one, sentencing involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. I'm not going to go through the rest because this is a mandatory sentence to be served based upon a conviction. Second, paragraph 2 of that section says the sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purpose of this chapter should be avoided.
I do just want to note that I do not know all the details. All I know is what was discussed here in this hearing and the comment that the girl made about this happening to her and somebody else multiple times. I could not find any record related to this case. I could not find a docket, a news story. I couldn't find anything. So I can't comment on if that was the only thing that he's being charged for or not.
What I would imagine is likely is that there were multiple offenses and they decided to charge the one that was most colorable. It does happen at times where, if you figure 12 to 18 years, whatever the hell it is, 8 to 12 years, she'll be an adult, she'll be on her own, she'll be outside of the influence of the individual. From prosecutor's office, that's kind of a win.
Yeah, I think he's a really shitty person and they use this to get him. Absolutely, my friend.
Sometimes we talk a lot about overcharging, where if you charge too much stuff, it gets the jurors distracted. This, you could argue, is maybe undercharged, but it got the results that the state would like.
It was probably one of those circumstances where they didn't have the solid evidence to
For the other
bring a higher
offenses,
charge.
yes.
Yeah. Okay. So here he
Sentence
goes.
imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. And number 5, the potential or lack of potential for rehabilitation or treatment. And it goes on to say that judges are encouraged to use alternatives to incarceration. That's not available in this case because of the nature of the crime and the mandatory sentencing. So, first thing I'm required to do is to set the range that the defendant is, and the court finds that based upon proof, the defendant is a range 1 offender, a standard offender, in other words, as a range 1 offender because according to the pre-sentence report, he has 1 prior conviction, that conviction being for violation of the order of protection, the misdemeanor. So he does have 1 prior conviction, but it's not enough to bump him into a range 2. Based then upon those factors, I'm required to consider the following factors in setting the proper sentence, and those are the evidence, if any, that's received at the trial and the sentencing hearing. Both at the trial and the sentencing hearing, I can consider the evidence, and I must consider that evidence. A pre-sentence report, principles of sentencing and arguments as to the sentencing alternatives, the nature, characteristics of the criminal conduct involved, evidence and information offered by the parties on the mitigating and enhancement factors set out in the Tennessee Code, any statistical information provided by the administrative office of the courts as to sentencing practices for similar offenses. None was presented at this hearing. Any statement of the defendant made on the defendant's own behalf about sentencing, and of course, Mr. Lockett spoke on his behalf. That is not something that the defendant did not make a statement. And lastly, the trial court must also consider the potential or lack of potential for rehabilitation treatment of the defendant in determining sentence alternative or the length of term to be imposed. The length of sentence, the court is required to consider the following under the Tennessee Code. The minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum length of sentence for each felony class to reflect the relative seriousness of the criminal offense in the felony classifications, and the sentence length within the range should be adjusted as appropriate by the presence or absence of mitigating and enhancement factors set out in 4035, 113, and 114. Although the trial court should also consider enhancement and mitigating factors, such factors are advisory only. The trial court's weighing of various mitigating and enhancement factors is left to this court's sound discretion. So going then to having found that the defendant is a
very
range 1 offender.
interesting point, and I hope Meg will start that and we'll address that later.
Do you say that again?
Address it now.
I had to pee. I just got back. What do you want?
So Mr. Jones said that makes sense. Wouldn't have been surprising if they mentioned the uncharged offenses at his hearing, but maybe the victim wants privacy. The issue is, 1, an uncharged offense literally cannot be brought up at the actual trial, period, at all, whatsoever, ever.
If it's uncharged.
Correct. You cannot bring that up. It is an absolute Fourth Amendment violation. So, no, it could not have been brought up at the hearing. Now, when you're talking about sentencing, can it be brought up? Yeah, potentially. But absolutely not at the trial, because it is absolutely inappropriate for an uncharged claim to be in the minds of the jurors when they are determining your other claims. And there are very, very, very specific exceptions where if it is a course of conduct, if it is... But yes, at trial, absolutely, Mr. Jones, you're correct. It can be done. But absolutely...
I was kind of confused by the whole thing because they were searching for case law for so long. I trimmed out so much and they were back and forth, like trying to figure it out. And I'm like, shouldn't this be a common thing? Like witness tampering is a thing. Like people screw with evidence and tamper with witnesses and all of that. And then I thought, well, you know, they're probably not stupid like that to do it on a recorded jail line. So they probably don't get caught until like after the trial or something.
Well, and we sort of talked about it a little bit privately behind the scenes, but one of the other aspects that I was thinking about when I was getting back to my office was, one of the reasonable aspects of it, why it doesn't come up, is because in a lot of circumstances, it doesn't get caught in that little interim between, charge, conviction, and sentencing.
Yeah, it's usually not a lot of time.
Which is usually maybe 10 days, if that. So I think it's relatively rare that it even gets caught that way.
It's this shirt.
There you go. Go to Meg's merch store.
Sorry. All right. No more M&Ms.
For a Class B felony that he's been convicted, Mr. Brooke correctly states that the range of punishment that I'm considering is a minimum of 8 years and a maximum of 12. And obviously, these two parties both sides have advocated their position. The defense is asking for the minimum, the state is asking for the maximum. In order to then determine that, I will look to what I believe to be the findings regarding mitigating and enhancing factors.
Why do they have to
With the
touch
enhancement
butts?
factors.
It's weird.
State refers to factor number 1 set out in the code, which is the defendant has a previous history of criminal behavior in addition to those necessary.
Honestly, if I were the judge, I would just break even.
The
Call it
defendant
10
has
even.
a
You'd what?
If I were the judge, I would just break even, call it 10 even, and by that point, she's going to be 20. She'll be in her mid-20s and decide what she wants to do with her life going forward. You've solved the problem.
There's also the punishment factor.
prior
But
criminal record,
he
prior criminal
Over explains.
conviction of violation of an order of protection. It is a misdemeanor, but it is also significant
dollar
because
store.
of the fact that it reflects that the defendant was placed under a court order and failed to adhere to that court order. And albeit a misdemeanor, it also reflects his likely not complying with orders of the court. Then Mr. Lockhart argues that the evidence that the state has presented regarding his behavior should not be considered. Well, this is the sentencing hearing that we're conducting today on June the 30th, 2023. The statutory factor, and I've looked at it at length, does not specifically state that previous criminal history or behavior upon which the court may find a mitigating or rather an enhancing factor must have occurred prior to the commission of the crime upon which he is convicted. In other words, there's nothing in the code or in the case law that I have found that says the only evidence of prior criminal behavior can be anything prior to his being convicted of this crime. And in fact, most of the time, in the case law, it's pretty clear. The appellate courts have upheld the fact that if a person charged with multiple counts of rape and is found guilty of one offense of rape, that the trial court sentencing can consider nonetheless the other offenses upon which he was not convicted, which would have occurred prior to his conviction as well. So there's nothing that says that has to be done in that fashion. The purpose of considering criminal behavior in addition to
discretion. So it's basically up to discretion. And I imagine that this judge is going to bring down the hammer pretty hard.
So he can use it if he wants to.
But he doesn't have
to.
Yes. I imagine he's going to use it pretty hard.
Amen, sister.
Necessary appropriate range is to show what type of an individual a person is for purposes of sentencing, whether or not they are willing to engage in other criminal behavior. Our case law that I've cited is pretty clear that it doesn't preclude the court from considering other factors other cases. And I would simply point out that, and I'm going to refer to one case in particular, which is State of Tennessee versus Melanie C. Moore. It's a 2017 criminal
Save Austin's,
appeal,
if you don't mind.
Court of Criminal Appeals
Hmm?
case cited at Lexus
Save Austin's,
982.
if you don't mind.
I still didn't understand you.
Save Austin's comments, if you don't mind.
Start. Got it.
Thank you.
Decided October the 11th, 2017. In that case, the trial court considered the factor that this lady who was on the trial could have been charged with kidnapping of two children. And there was an objection for him having weighed that and having considered that and stated that during sentencing. I would simply refer to you what the trial court there, the Court of Criminal Appeals says. Here the defendant specifically argues the trial court erred in deciding the length of the sentence for count one because the trial court improperly considered the defendant's uncharged conduct over Tennessee Code annotated section 4035-114-3, which states that the offense involved more than one victim. The defendant knows that the trial court frequently referred to the defendant's kidnapping of the minor victims throughout the sentencing hearing. And then we go on to state the trial court, it goes on to state that in other cases, the trial court may look behind the plea bargain and consider the true nature of the offenses committed, citing State versus Hollingsworth. In other words, a trial court is not restricted to considering only the crime to which the defendant pled guilty, but may consider what evidence shows actually happened. Going on to say in other citations, I'm omitting the citations, that was State versus Jennifer Hargrove. Our court has previously affirmed the trial court's decision to look behind the plea bargain at the facts of the case, including a defendant's uncharged criminal conduct.
Amen.
State versus Lane, 3 Southwest 3rd, 456, Tennessee Supreme Court decision in 1999. That case affirmed a denial of an alternative sentence in part because the defendant's criminal record included 2 uncharged incidents of statutory rape and 4 uncharged incidents of official misconduct emanating from the relationship with the victim. And it just goes on and on and on in that case, talking about uncharged conduct. Revealed during affirming a sentence where the trial court considered uncharged conduct that was revealed during the trial. Case after case. So that court concluded that the trial court did not err by considering or referring to the defendant's criminal conduct as kidnapping through the sentencing hearing. Based upon all of that and the prior cases I've cited on that, it's this court's opinion that the evidence of the fact that this defendant clearly intended to present false evidence to this court in obstruction of justice in this proceeding, that he is guilty of, by a preponderance of the evidence at least, the court finds that the state has proven by a preponderance of the evidence that the conduct of the defendant, that he solicited his brother to present false evidence, to manufacture and present false evidence, and that there are a number of criminal statutes that would have applied, but it clearly would also be tampering with evidence in a criminal case that upon all of this. It occurred after conviction, but before the sentencing. So I find it to be prior criminal history of criminal behavior, a previous criminal behavior that would apply under Rule 1 or Factor 1. I would also state that that is not the only factor that I'm relying upon.
That is true.
It is simply a consideration and observation. I place greater weight upon the following factors. Number 4, the victim of the offense was particularly vulnerable because of age. Yes, it is a factor that the court finds that it was a statutory offense that basically said that he was convicted of sexual battery of a child under 13 years of age. That's the nature of the child. So that is a part of the consideration. So number 4 cannot be considered as a factor for enhancement in this court's opinion because it is part of the crime itself. Number 5, the defendant treated or allowed the victim to be treated with exceptional cruelty during the commission of the offense. I don't find that to be the case. Yes, I know Mr. Brooks argues that this was exceptional cruelty to do this to a person's own biological child. However, fact of the matter is that I don't think that factor deals with that type of psychological injury. I think factor 6 does apply. The personal injuries inflicted upon the victim were particularly great. This court has presided over this case for a couple of years during this time. I have observed LU, the victim in this case, come into court on numerous occasions. I have observed the emotional trauma that this case has imposed upon her, having to come into court and testify on multiple occasions, on motion hearings and at trial. And it is clear from my observations of her that she has suffered an irreversible, I hope not irreversible, but an undisputable psychological and emotional injury as a
Phrase
result
carefully,
of this.
Judge.
I think
I don't hate the day or the purpose of the day. I hate the way the day is celebrated because it causes a traumatic reaction to not only my pets, but also several veterans I know have a really hard time making it through the 4th of July because people want to go light fireworks and get drunk and celebrate and act like idiots when they don't even know what they're celebrating for. So I think I can have more respect for the day while hating the fireworks than most people who are out there acting like yahoos.
Well, and you
setting off
can
bottle rockets.
You can educate yourself in about 3.5 hours. And I go through the actual Declaration of Independence and show why that was the foundation of our Constitution, Bill of Rights.
One of my ancestors
it
signed
was
that
not
thing.
necessarily a physical injury that she suffered, but it certainly is an emotional injury. The proof before me is that she's undergoing therapy and has been for years. And that's consistent with the testimony at trial. He was not convicted of multiple accounts because he was only charged with these others, but there was testimony that this had been ongoing for some time. As a result of that, this court is of the opinion that that is a major factor. The personal injuries inflicted upon this victim being molested by her own father over a period of time, including the evidence that she testified at trial about that the jury found him not guilty of. He was acquitted by it, but I still consider that evidence in determining that that is a major factor upon which I place great emphasis. Factor 7, the offense involved a victim was committed to gratify the defendant's desire for pleasure or excitement, clearly applies to this case. I do not believe that the defendant who did, his story about that he just accidentally woke up and had his hand on his daughter's breast and instead thought it was his wife is not, in my opinion, not a credible explanation,
That's not
period.
entirely
I think
correct.
clearly these things, according to her testimony, the victim, that it was done to gratify his desire for sexual pleasure or excitement. And factor 14, the defendant abused a position of public or private trust in a manner that significantly facilitated the commission or fulfillment of the offense. I don't think that factor requires that there be proof that because he was a parent, he called her to the bed or anything else. He was her father. There's no greater obligation that a person can have than as a parent to protect your child from these types of things happening. To have a father who willingly and intentionally abused that position of trust.
No, I'm just articulating what I have seen throughout my 40-some years on this earth. So I've seen
I will
quite a
say
bit.
from my perspective, there's something a little bit different when, you hear pop shots go off in Brooklyn and the dog doesn't want to go out to take a walk anymore. That has a similar effect.
Trust and use that position to obtain his own sexual gratification, one of the worst things that a person can do. And I find that that is a major factor that deserves great weight. So I have found.
Get past this. I don't want to hear about this anymore.
Applicable. Factor 4 cited by the state to not apply because of the fact that the offense he was committed or he was convicted of included the age requirement of the defendant. Factor 5, I do not find because there was no evidence of any cruelty during the offense other than the nature of the offense, but I do find factor 6,
I
7,
burn
and
myself with
14,
burglars.
so 4 of the 4 aggravating factors that, in my opinion, apply. Then moving to the argument made by the defense for the mitigating factors. The defendant's criminal conduct neither caused nor threatened serious bodily injury. Serious bodily injury depends on different things, but the case law clearly indicates that psychological or emotional damage can be serious bodily injury. I do not find that to be applicable. I find that she has suffered serious bodily injury, and that my observations of her in person while she testified and the trauma that she
I always
experienced,
thought that
emotional
Canadians
upheaval
sorry
took place.
after every time they
Hmm?
I always thought Canadians said sorry after every time they fired a mortar.
You're cutting in and out.
Oh, sorry. I believe that Canadians said sorry every time they fired a mortar. They didn't necessarily know where it would land. That's all.
I am so sorry, but thank you for your service.
Likewise. That's very difficult.
Having to see what the long-lasting repercussions are is really
In
hard.
a particular hearing, she stood and walked out of the room because she was so emotionally distraught. The defendant acted under strong provocation does not apply. I believe the defense actually cited number 1 and number 3. Number 3, substantial grounds exist tending to excuse or justify the defendant's criminal conduct. I find that does not apply. His statement to law enforcement that it was an accident that he is completely contrary to the testimony of the victim, in this case, LU, who testified this was not an isolated event, but rather a repeated course of conduct. And number 11, the defendant, although guilty of the crime committed under such unusual circumstances, unlikely that a sustained intent to violate the law motivated the criminal conduct. If nothing else, the evidence presented by the state today about his soliciting a false report to be, or a false evidence to be introduced to this court, clearly shows that he has a sustained intent to engage in criminal conduct, and it does not hesitate from doing so. But nonetheless, I don't find that this was unusual circumstances that I don't find this factor to apply, because I think the young lady testified that it occurred over a course of time, that it was not an isolated event, and it repeatedly occurred. So I do not find that to be. And number 13, any other factor that the court may consider for purposes of the chapter, and he cites the lack of previous criminal history. I have found the criminal history does apply in number 1, and his work history. I do find that there is, that he was.
So what, he had a job?
That is only a very minor consideration. Based upon
Well,
that, it is this court's
Right, I
opinion,
got it,
based upon
but
the enhancing
pause
factors.
for one moment.
okay,
NCTPL.
it's almost done. He's just got like 2 or 3 more sentences.
1 second.
No, I know. I'm just telling you. Go ahead.
NCTPL.
Mm-hmm.
It's okay. We got a really good song out of it.
That his sentence should be 12 years in the Tennessee Department of Corrections. Be served.
12 years.
That is the judgment. He ordered to pay a $25,000 fine,
$25,000 fine.
and he'll be on the sex offender registry for a lifetime, and he will also be under community supervision for life.
Wait.
Registry
So
for
he's
life
in
and
jail time?
supervision for life. What?
He didn't. What was his actual set in terms of duration?
12 years.
All right, so he went maximum.
Maximum.
Then on top of that was further supervision.
$25,000 fine.
Okay.
He'll be on the registry for life and community supervision for life. Which generally is part of being on the registry. When you're on the registry, you have to check in.
Yeah.
You can't move. They have to know where you are at all times.
All right. I'm kind of okay with that. I think
I don't
TT
think he's
Taylor,
done yet.
I like that idea that money should go into child's college account, but I don't think that they can legally do that. All right, so he's got 12
It's the judgment of
years,
the court.
rest of his life on the register. Okay, I guess.
Can we listen to the rest of it?
Yes, we can.
Thank you. It's really hard to hear. He talks really soft.
In this case. Having rendered that verdict, he is remanded to the custody of the Department of Corrections to begin serving his sentence. We will, with that, adjourn court.
Your Honor, had we already set a motion for new trial date?
Don't know that we have, we can do that now if you like.
Tell you what.
I know you
Sorry,
have
I thought
not
there
yet
was one more
so
part
we
to it.
haven't had the sentencing hearing, but. you're
So
able
there
to
isn't
do
a part to it.
August 28th.
I told you I wouldn't talk.
Yes, Your Honor.
No, you can talk now. There was one other thing. There was something else, but they're filing a motion for a new trial, which of course will be denied, but that's required in order to be able to appeal.
Correct.
But this is important. So watch him leave. Look at the two sides. There's only one person, the tie-dye, which I'm assuming that's mom. He wants to make a motion for a new trial, basically the appeal process.
But I thought this was actually his first appeal because he said that it was de novo from
This
the
is
trial
his
court.
sentencing.
But I thought that
Look who's
it
there.
was de novo.
Hold on. Look at the bikers. It's the, oh, crap. Iris, what's the name of them? I forgot him. Melly told me earlier. It's the group from around the country that goes to trials that are involving children and makes sure that everything is okay, nobody messes with them, nobody does anything, causes any problems, everything is
Give me their
smooth,
information.
all
I
that.
want to send them money.
Bikers Against Abuse, is that it?
All right. I'm willing to send them money.
Absolutely freaking amazing. I saw it and I thought, is that friends of theirs or whatever? And then I saw what happened. They literally stood there and this keeps playing and the victim comes into the courtroom. So I'm going to stop it right here. But they stand there and they wait for everyone to go out and they shake their hands and wait until and follow them out in a group.
I'll say this. I'll do it this way. Up to $50. Anybody who sends them $10, I will match it for the first 5 people. Send it to me over on Twitter, JRobinLaw. I'm down.
Phenomenal organization. Wow.
I mean, you want to join me in that, or I'll just do it myself? That's okay.
Maybe next month.
All right, fair enough. But yeah, anybody who sends me, the first 5 people who sends me that they send $10 their way, I will match it, and I will send you back the receipt. So I'm totally okay with that.
Awesome, right? I mean, with all the bad stuff we have in the world, see, I caught myself that time. For them to do something like that, I think it's absolutely amazing.
Fantastic.
It's like heartwarming for all that nastiness that we just watched. And that was a lot of icky. But there was a lot of interesting legal arguments, but it got drony because he was trying to over explain to make sure everything was on the record to ensure that they were solid on appeal.
Amen.
They didn't want to take the chance of him being able to appeal this. So he's stuck in jail for all that time.
Good. And thank God. Because, like I said at the very beginning, my opinion is when you engage in that sort of behavior, you should be executed. But if your state does not allow for that, then I guess if this is the best that we can do, then so be it. At the very least, we did the best that we could.
I have seen some of those, and honestly, y'all would be watching me on a Zoom hearing because I would be locked up for what I would do to those people if they acted like
I'd
that.
be the first one, if you have me in your phone still, I'd be the first one to come and defend you.
Like, I just can't, I can't comprehend the level of evil to go and attack people at their, it just,
Most vulnerable state, honestly.
it is. And it's just so dirty about it.
It's why I don't cover those stories, and we've talked about it.
I know, it infuriates me usually, but this one wasn't, it wasn't the real deep.
No, it
No,
wasn't.
into
It
the
wasn't.
issue.
It didn't go into that particularly, but it's
And how weird, quirky, go get
to
a
be
Dollar
told.
General phone and make posts, but it wasn't a
It
fake
needs to be
profile.
told. It's a story that needs to be said. And now I'm actually reconsidering my rule on that one. Because there are circumstances like this where
Thank
you
you,
gotta tell the
Iris.
story. I don't know.
Yeah. There's some stories that need to be told, and it needs to be told for the fact that people need to see real life.
That there is that degree of depravity that actually exists in this world.
Yes, because so many people walk around with that it'll never happen to me attitude, and it happens.
Yeah.
It freaking happens.
You're not
Trust
wrong.
me. I never thought that anything was going to happen to me, and then all of a sudden one day I can't walk, I can't talk, I can't do anything. Like, that was never even crossed
Wasn't
my
part of the
mind as a
design.
possibility.
Yeah. It wasn't
Thank
part of the
you.
design. And I genuinely, I agree 100% with that comment.
Thank you.
And to Taylor as well.
She's awesome.
It's not the kind of case that I would have covered if I did not know you. So
I shoved some of this stuff down your throat, but hey, we're broadening your horizons.
It's a good thing. Like, you were so kind, and everybody, please, by all means, support Meg as much as you possibly can, because I probably would not have a channel if not for her support. I mean, I remember it was Christmas Eve, and we're texting back and forth when I'm considering giving up the channel, and she pushed me back into doing it. So
No, don't do that.
Who's
Who's gonna ramble on for 4 hours at night when I need something to watch on TV?
Yeah, but guys, seriously, anybody who's within the sound of my voice, please support Meg, because I would not
Thank you.
without her.
You guys are awesome. All right. Yeah, there's so many reasons why so many things happen. Who knows?
It's all changed, and it's always going to. That's just the nature of how it all works.
That is such an accurate comment. And it's not just people. Like, our kids are not being taught in school the skills to be able to survive in the world.
Yeah.
And it's up to parents to do it. And the economy is so bad that it takes two people to work to support a household. So when do you have time to teach your children all of these things that you're supposed to be teaching them on how to be a good person and how to?
Well, I mean, I think to some extent what it really comes down to, and there is an argument to be made, that the idea of the two income
Let me drink.
households really did cause some degree of damage. I
Oh,
mean,
huge,
and it's
massive.
not, in my opinion, I don't think it's particularly sexist because, you know, if it's the man goes to work and brings in the paycheck, the woman runs the household. She's in terms of how she has fundamental control in terms of how it's spent. Actually,
It doesn't even matter who is who. Like
and it could be either
the
way.
man can
I
stay
don't
home and the
care. It's
woman
not
can
the
go
point.
to work, but it really takes, if you have kids and you have a house, it's a full-time
You
job.
need somebody. There was literally, if you go back to the Middle Ages, you had a castellan who their entire job was determine the value of the estate, what it was bringing in, organize to make sure that the person that had the estate was taken care of. We moved to the modern age, and generally speaking, that was the wife, but it didn't
Welcome,
necessarily have to be.
welcome.
But it was a good. It was a good dilution of responsibility, where one handled the household, the children, etc., and the other went and made money. Then they come back together. This is the old story of family dinner. And you call it an evening and you start over again. I don't know. It just, maybe it is super conservative in a way that people don't particularly care for anymore. But I think it was relatively effective. I don't know.
Who was it? Was it Tammy that asked me about the mug? Let's see if you can see that.
Yeah.
The Judge Dad mug.
Yeah, Bill Rhodes, it's 10 a.m. Do you know where your kids are? Absolutely right.
Yep. They also were advisors to King Henry VIII. That's exciting.
Well, you know, you can't be 100% on the historical marker.
Supposedly, one of them is an illegitimate son of King Henry VIII, but they can't prove it. And I wrote him and I said, hey, I can totally prove that. That crazy went straight down the line. We still got it. It's good.
Well, you tried to do the look back on my ancestors.
I'm still working on it, but like everybody's named the same damn thing. It's really hard.
That's the nature of Celtic civilization, generally speaking.
We need to sit down at some point and get started and make sure I got the right people, and then we can keep going. Iris, I answered you on Discord.
Yeah, I know. But anytime you'd like, I'd be very happy to go get lunch. Yes,
Yeah.
the O'Brien.
I'll text you. In a couple weeks, I have a doctor's appointment down there, so maybe I'll swing by after.
All right. But yeah,
Or meet you
O'Brien
somewhere.
lineage is not. Let's put it this way: there are a lot of knots in that family tree.
So, okay. I don't really have anything else exciting. What about you guys? Questions?
I mean, part of me wants to do the last cigarette, but I don't know if that
I know.
YouTube would particularly like that in your format.
Well, if there's 165 people, so
All right.
tell me what's up. What's going on?
Sarah already said.
Oh, look. Wait, we can do the Q. I saw Team Skeptic did this earlier, and it was kind of cool. So we started Q&A. So ask me anything.
There you go. Although I imagine Sarah apparently does not appreciate my presence on the panel. So that's unfortunate. Guess what? Ultimately,
Is that an ex-girlfriend of
her-
yours or something?
it's her call, not yours. I don't know.
John,
I guess I'm a little bit more controversial than some of your folks particularly prefer.
so there's a button at the bottom of your chat and it says ask a question. Think of something creative. I will answer anything almost. Very
Well,
few things
I
I
will
won't
say
answer.
it this way: I will answer anything as long as it's good taste and is my ability to respond. And I will do that as long as the cigarette that I'm not going to show on screen continues burning.
What was I going to say? I enjoy your perspective because it's so much different than mine. And Iris had a good point in that I'm bringing emotion into it.
Absolutely.
And I look at a situation and I think, oh my God, use common sense. Yes, she had drugs. Yes, she got pulled over with drugs. Like,
And there's nothing wrong with that. That's one of the things that I think is really great about us working together is I consider you an ombudsman for all the people in the chat who are not necessarily legally trained, but are interested in the subject. And
there's being interested in the law, and then there is like living the law. Like I enjoy legal things. I enjoy the legal process. I enjoy learning about the crime and then watching it go through the system. Whereas you enjoy the structure of it and like
yes.
the bones of it.
No, that's absolutely fair.
I think I'm probably not using the correct terms. Just
Well,
FYI,
I'll phrase it
I went
this
to
way.
I went to the doctor yesterday. He told me that from now on, when I wake up in the middle of the night, I have to get out of bed. I'm no longer allowed to be in bed if I'm not asleep. So when I got up to pee, I was awake and I couldn't go back to sleep. So I thought, okay, well, I guess I have to get up and go sit somewhere else until I'm tired again. So I've been up since 1 a.m. For what? No freaking clue.
Well, I can tell you the answer to that.
My body hates me because I slept all day yesterday.
No,
I don't
not
know.
particularly. The whole reason why that advice was given to you is because it prevents against potential bed sores. And so the idea is that if you're at least moving around, then you don't have what are really pressure ulcers. We call them bed sores in the world. But it's not advice. The idea is if you're awake, don't stay laying in a supine position because if you're not asleep, then potentially there can be the reality of pressure ulcers. So it's good advice, but the why is what I'd like to try to get to.
It's about sleep
It could
health,
also,
making your bed a sleep place.
yeah, there's that too. That's more psychology, psychiatry. The other aspect would be that
Well, it was my psychiatrist that told me it.
why
So
we sleep with a pillow is because we tend to want to have blood flow down to our lower extremities because your blood pressure drops significantly during sleep.
and I have a slip disc in my neck and it hurts if I don't use a pillow.
Right. So there are so many different reasons why it can be. And they don't necessarily know which, but they know that it is good advice, if that makes sense.
Okay, pup mom, RN would like to know, how are you feeling today? I'm actually feeling kind of crappy. Oh,
Oh, I thought that was for me, but you
okay,
can go
yes,
ahead.
go ahead.
No, you go ahead. You've already started.
I am a hot mess. My sleep schedule is completely off, and I don't know how I'm going to get it back on there. I am tired of trying to do everything that needs to be done, plus 10 other things, and still not getting them done. And I am really tired of every time I go to the doctor having to explain my entire health history and then still not understanding it and telling me that, well, if you could just go exercise, your life would get better. Well, no shit, Sherlock. Don't you think if I could do that, I'd be doing it?
Fair point. I don't
No,
know.
I like being miserable. I like being fat and miserable. Sorry. Like, what the hell do you think? Like, I'm doing everything I could do. Well, have you thought about physical therapy? For what? To help heal you. Do you know what MS is? Like, you can't go do some squats and fix a freaking stripped nerve myelin.
Yeah, well, go
I
ask
was
an unregulated chiropractor, and they will spread.
you're kind of in and out again. Are you on Wi-Fi?
No, I am not.
That's
What I
probably
was
why.
going to say is go ask an unlicensed chiropractor, and they will probably swear that they can.
Yeah. I know. I try not to rant too much, but anybody who has
It's
any
okay.
autoimmune invisible illness just totally went, yeah, I know what you mean. So
It's never
I
lupus.
knew you were
just remember.
saying that in your head, so it made me feel a little better. So how are you today, John? Tell us about your day.
My day consisted of cleaning my apartment and hopping on here, doing a little bit of research. At 6 o'clock p.m. Eastern Time, I will be doing a show on the Declaration of Independence for the 4th of July and how that really was the foundation of our Constitution and our Bill of Rights.
Do it.
I kind of wanted to rant about this last case, but
Welcome,
as
Bella.
I thought about it more, the judge was so reasonable
Wasn't he?
that
He
I don't
explained
know.
and justified everything. It's like you really couldn't pick anything apart.
I think he kind of diffused my wanting to rant on him.
Oh,
So
I wonder
I don't
if
know.
he does house calls.
Yeah, I literally everything how he described it. I mean, the argument itself was absolutely ridiculous as a practical matter. I mean, the reality is that you engage in essay with a minor.
Mm-hmm.
So you just lose every time, all the times, every time. So when we had spoken about it, it was a question about using prior bad acts in the sentencing phase, which may or may not be appropriate. I think in this circumstance it absolutely was. I think the child was fantastic.
Oh my gosh. And yeah.
So I other than precisely what the judge did, I can't imagine what would be another appropriate sentence.
No, that's the best he could do under those circumstances. And
Like I said, in my personal opinion, I'd prefer that he be executed.
yeah, but we can't always have what we want.
No, unfortunately. Although more recently, maybe we can.
Yeah, right. Yeah.
It's been a really good week for the Supreme Court, in my opinion.
Hold on, I have one more question. How do I decide what to cover? And that's kind of a big one. Because it's all over the place. Like for example, I don't have cable, and I don't have any kind of the Netflix and all that. I have Discovery Plus. A little addicted to true crime. Other than that, all I have is YouTube. So I was watching something, and then this clip auto played, and I kind of heard the first argument. I was doing something on a laptop, but then when I heard the brother testifying, I was like, "What?" So I rewound it and watched it, and I was like, "I got to get that." So I ended up doing it. And so a lot of it comes from just watching it. I have thousands upon thousands of videos that I have streams that I try and go through, but one person and how many hours each day, it's almost impossible. A lot of people suggest stuff on what to cover, like Law sent me an email about David Chase. Like I never would have known about David Chase. It was just some rando in a bond hearing with Judge Manning. But then once you dig into it, it's like, what? Yeah. And other things, it's stuff that I pick up from my work with like web sleuths and things like that with missing people that lead me to something else. So,
Well, and I guess from my perspective, things are fairly similar. Um, I have people that message me recommending certain stories, but usually my stories come from either things that are out in the ether that people don't pay enough attention to, and I think they're kind of fun and interesting, or in a similar vein, people will send me things, and then when you start doing a little bit of a deep dive, you're like, all right, there's actually something here that's interesting and worth covering. Um, and then obviously people who are familiar with my channel know that if there are local cases that I think are interesting and I can go to the court and do it that way, I'll try and do those. But
you like the long form trials a lot, whereas I can't keep up with them.
I enjoy
I
them.
can't sit here that long. Like I'm already, my back's spasming and I'm like, ugh.
Well, that's kind of the benefit of, I guess, being a little bit younger. But yeah, I don't mind standing in.
I think he
chair
just called
and-
me old, guys.
I
Wow.
tried to do that as nicely as I possibly could.
He called me old. What do you think we should do about that?
Well, I could add to it and call you fat too, but
Oh, you're gonna get so much hate for that one.
that was a joke. Please, everybody. I love Meg
You're
did
fine.
that.
You're fine.
I met Meg, honest to God, and I hope you don't mind me sharing this story.
I don't know what story
when
you're
I
sharing, so have at it.
when I first started my channel, Meg reached out. She liked what I was doing, and she offered to do thumbnails for me. And if you go back to the back catalog, all those thumbnails are Meg's work, and it is absolutely fantastic. And I could not be more happy than to have had Meg reach out and for her to be in my life. So thank you.
I have called John a lot worse than fat, so we're good. We're all good. I
Rightfully
promise.
so.
Yeah, we've had a little roller coaster of a friendship. We don't have a lot of a filter, so we kind of tell it how it is.
Can I smoke on your channel, or would you prefer that I block my screen?
I don't know. Am I gonna get demonetized for it? Because right now I'm still monetized.
I don't know. I have not put this as a simul stream. So I'm going to stop the cam, but I'm still here.
Okay. Right? We got to teach them how life was, back in the 80s when shit was cool.
I think I'm familiar with that concept.
Don't judge me. Bitch.
I always thought that I was an old soul in a young body.
Yes, I think that's because you're very refined. Take care, honey. You have a fabulous night setting off your fireworks.
So
This has been fun, and John is like a fine whiskey. That's adorable.
yeah, I get better with age.
Uh-oh. It's going down for reals.
Oh, that's gonna get hard.
I know.
Somebody said Pup Mom asked a question that I'd like to respond to.
I'm 29. What are you talking about? Pup Mom. Oh, I had Austin starred. Did you still want that?
Yeah, pull that one up first. So, plus, I don't think many people think 10 years in the future, too much prison time, you get a diminishing return for a punishment and a deterrent. And that is Austin's opinion. Respectfully, I disagree with that. I think that strong potential consequences are precisely where you get deterrent effect. And I don't entirely understand the diminishing return. Remember, there are 5
Wait, are you saying like if they're in there, Austin, I'm asking, if they're in there for such a long time that the rehab starts reversing type?
Yes, I think that's where he's going, but I'll let him answer.
Hey, honey, I'm glad you weren't here 5 minutes ago. Please don't rewind and go lay down and have a good night. Love you.
But no, I generally
had a sorry, go ahead.
No, go ahead.
Mine was totally not important.
All right, so what I was going to say is there are 5 theories of criminal justice. It's retribution, incapacitation, deterrence. Those are the ones that I actually give a shit about. Rehabilitation.
I'm so excited. I feel like I should take a picture.
And what the hell is the 5th one? I don't know. There's only 4 that I care about. So the issue is that incapacitation is useful with long prison sentences. So in that regard, it is serving one of the fundamental purposes of criminal justice, is that you are removed from society so you can't harm others. So I don't know if that necessarily answers your question, but I hope that it gets close to. And if you have a further question, I'm happy to answer. But yeah, so is it? It might just be only 4.
Is it also the fact that there's so many ways to shorten your sentence these days that that number doesn't really mean what it used to mean?
Well, federally it does. There is no way to shorten your sentence under a federal crime. So state law does give you the opportunity to reduce it. There's no such thing as, time for good behavior when it comes to federal law.
Interesting. I did not know that.
So if it's 20 years, it's 20 years, period.
So that's why in the Derek Chauvin case, they took the deals they took were all equal or less than their federal sentence, so they could serve them simultaneously.
Correct.
Because they were going to be there anyways.
Correct. And that's why if you've noticed a number of videos that you've done is we would like to get the arraignment done. We would like to get the probable cause hearing done. So you'd start getting time served
Mhm.
as a credit toward what might be the ultimate sentence.
I know. Remember Tattoo Guy's meltdown because he wasn't getting credit for it?
Yes, I do. But that's one of the
Sorry.
reasons why they try to
Can't
do
sit
that.
still.
So throughout 10 years versus 15 years versus 20 years, I think much beyond 10, the concept of longer is all moot. That was kind of my point in 200 characters or less. All right, so let me answer that because it depends very much upon the state in which you were sentenced. So let's take New York as an example. And I like using it as an example because it has a very weird sentencing structure. But if you are convicted of a felony in the state of New York, and I'm not necessarily going to get this entirely right, but just as a general matter, because I'm not looking it up right now. Class C felony is between 2 and 5 years. A Class D felony is between 2 and 10 years. A Class C felony is between 2 and 10 years. A Class B felony is between 2 and 25 years, and a Class A felony is between 2 and life.
All dogs are lap dogs.
So I don't know if I exactly have the numbers correct, but a judge can always depart downward toward 2. So that's why sentencing does potentially matter. New York, by the way, is also one of, I think, 2 states where dangerousness to the public is not allowed to be considered in bond hearings. So it's a little interesting in that regard.
What are you talking about? He only did it twice, and I yelled at him both times, and they stopped.
I thought I was pretty good.
Like, if you breathe while the video is going, people freak out. What they don't realize is by not talking over the video, I am taking a huge risk in losing my channel. Why? Because
Copyright.
YouTube is monitoring the audio. And if that audio is identical to somebody else's audio, then there's a strike.
Then Content ID automatically strikes it.
And if I'm talking over it at points where it doesn't matter, like when they're talking about getting a folder out of the back room, then I'm protecting myself. Because
I'll give the perfect example. Our last show, when we were talking with the Queen, and it took me about a week and a half in order to allow it to be reconfigured so as not to violate YouTube's copyright policy. And I know you told me, I hope you don't mind me telling the audience, that you just didn't bother trying to edit it in order to bring it back up because it wasn't worth it.
I spent like 8 hours letting it spin.
So there is a reason why we have to comment on top of the videos that we show.
Gunshots. No, that's scary. You know, like almost every year on the 4th of July, somebody is killed by a stray bullet. It's not cool. Not cool at all.
I mean, in fairness, that's still fewer than people that killed by having vending machines fall on them.
Thank you. I like my Judge Dad shirt. And like I said, this is a made at home one. The ones that are in the store are much better quality than this. This was just, let me see if I could do it and what it looks like. Yeah, the audio was really low. It really sucks because once you get it in StreamYard, you can't really play with the audio.
There's not a lot of control that you have.
Yeah, there's hardly any control. It's all automated. Judicial opinions and orders from federal judges are not copyrighted. It is federal work product. For state judicial opinions and orders, the court will not allow enforceable copyright. I actually read something the other day, and I can't remember where I read it, but it was
This
something
was
to
the
do with a
case in
court.
Georgia. Sorry, go ahead.
It was something to do with a court about requesting records. I don't know if it was body cam footage or some other something, but it was saying that telling the media you could do that and copyright it. And I was trying to figure out how a media entity could copyright
So
court file.
there are two issues. And actually, it was Nick Ricada that did the original research on the subject, and was very, very thorough. There then was a Supreme Court case where Georgia wanted to copyright its internal codes, and they determined that's not allowed.
Yeah.
So if it is a public hearing, if it is a public document, if it is available essentially to a FOIL or FOIA request, depending upon your state, or a Open Records Act request, then you can't maintain a copyright on it.
But this YouTube streaming has never had a court case. It's never made its way
Correct.
through the system on how that works and
There's
everything else.
nothing specifically on point.
Yeah, and that's where the big question is going to come. Take care, Pup Mom. I hope you feel better soon. And I hope you don't have too bad of a night. Thank you very much. I really appreciate it.
So, girl next door, give me
because-
the case citation, because
This isn't. Sometimes you have to pay for FOIA records.
Yeah.
Lots of times you have to pay for FOIA.
So what? That doesn't mean that there's a copyright on it.
The way I understand it, the YouTube stream is not part of the court file. There's a service that is also participating in the Zoom hearing that is transcribing or recording. Some of them, he said the name of it the other day and I meant to write it down, but he said I got to turn the whatever system off, and that's the transcription system.
Yes, I know what you're referring to. There is a case that if you actually have in the court a stenographer, then they can copyright their specific transcription. However,
but that wasn't what I was saying. I was saying that stream does not become part of the case file.
Correct.
This YouTube stream, like after they're done, it goes away. Like everybody takes the piece they need to do their job.
And then generally speaking, they take it off of YouTube as well.
Right.
So
that's where it gets kind of interesting.
They stream it while it's live, and then they take it back off. Mm-hmm. So if you capture it while it's live, how is that, in my opinion, fundamentally different from just being an average citizen walking into the courtroom and typing down everything that they say and leaving? I have every right in the world to do that.
But you don't have the right to bring a video camera into the courtroom.
No, I might not.
My argument against that, because that's the one that always caught me. Everybody that I've opposed this with has always said there's no cameras allowed in the courtroom without permission. Yes. The purpose of that is to prevent them from recording sensitive information, from taking pictures of the jury, from recording attorney-client conversations that are privileged, and then disseminating those somewhere. So when it's streamed on YouTube, precautions are taken to ensure that those items are not broadcast. So you've already taken out the problem. So there's no reason for it not. There's no harm in it, I think is.
I generally agree with you.
Another one of the arguments is that if somebody else takes that record, they could manipulate the video, bring it back to court, and try and say, look, this is what happened, when that's not the actual record of what happened.
So Mighty Spork makes a good argument that it's the difference between intellectual property and transitory property.
All right, you tell
This
him
is
that
an
while I get a
argument
drink.
that is very law nerdy, but it essentially suggests that anything that is capable of being viewed when you are legally in a public place, there is no property rights that attach to those. There's also no privacy rights that attach to those, interestingly enough. So you see this a lot with like First Amendment auditors, where they go to, I don't know, City Hall or whatever, and they're just, taking videos in the lobbies or whatever. And somebody says, well, people are uncomfortable because they might be divulging personal information. But here's the problem is, as a practical matter, from a First Amendment perspective, if I can hear you say that information to one of the clerks, why is that different from me audio recording it? If my own memory can capture your social security number, then you are giving it in public, period. That's the end of the discussion. So why does the means by which it is being captured matter? I don't know. Do you follow what
I
I'm
know.
saying?
He doesn't do the unicorn. It's a little picky.
All right, the other one seems.
Oh yeah, they have their stuff all the time. That's part of the lawsuit. I don't know if you watched our Karen and her soft-sit son live stream. If not, you should, because we're awesome. And
I agree.
we didn't argue much in that one.
No, we mostly agreed.
Pretty good. But one of her arguments is that the sheriff released the body cam footage, which contained her phone number, address, place of employment, all kinds of stuff.
All of that is foilable.
But it's right on the website. But that she there was over 1 million views, and he did it intentionally to hurt her. It was a targeted attack, is basically what she was saying.
Yeah, that's a ridiculous argument.
So
it's an absolutely ridiculous argument, and this is why I've talked with Meg about this before. I've talked with other guests on the show when I do it on my channel. One of the reasons why I am very happy with using court TV footage is because Nick basically took them to the cleaners.
was it court TV or Law and Crime?
Law and Crime.
It was Law and Crime.
Yeah, it was Law and Crime. That's why I use them for most of my streams, is because they got taken to the cleaners and they realized that they're not going to win. So they don't bother anymore. Doesn't necessarily stop YouTube every now and again, but generally speaking.
So there's copyright in the real world, and then there is YouTube rules, and they are night and day.
Yes.
And they don't mix and match. So everything you know in the real world, when you come into YouTube, whole new set of rules.
Yeah, but that also becomes a little bit interesting with a handful of lawyers. I think between us, at the very least, the Twitter group is, what did I say, like 8 countries and 36 states.
Yeah. YouTube
I
doesn't
mean,
care.
there's a brain trust that
they
we all
are
stand up
like,
for one another,
this is what we want. This is what you're gonna do.
and we're
Okay,
pretty good at what we
bye.
do.
Yeah. Bye. They don't care. They
No, and
they look at a video, say this video that I just showed. If John turns around and puts that on his channel, I'm going to get a notice, that a copyright notice telling me that John used something that I first distributed. Now, copyright is in the legal realm, and they're just doing that saying, hey, FYI. But I can't file a copyright claim against him because I didn't create that content. There's somebody else's work all mixed into that.
Yeah.
So I can't copyright that. Somebody should tell Chili that, because, you know, he keeps filing those against Skeptic, and yeah, that's not how that works. But outside of that, YouTube has a reuse policy. So if John puts this video up and Mike goes, hey, that's a cool video, I'm going to put that up. And then Biggin goes, hey, I like that, I'm going to run that. All of a sudden, there's 5-6 copies of the same video. YouTube does not like that. And they will take the lowest man on the totem pole and strike him, which is what they did to me. And the purpose was, I had the same content as a bunch of other channels. I tried really hard not to. And it doesn't even matter if I put it up first and those other channels did it after me. If they're bigger channels, I'm the one that's going to get hit for it.
And at this point, you're a bigger channel than I am.
Because I am awesome.
So
Don't judge me. I feel like I'm pulling my boobs up every time I do that. I was trying to find a good way to do that, and there's really not one. I can't get my shirt in the picture. Don't judge me. I'm really not trying to, like, be suggestive or anything.
But no, but
Dad. Poor Judge Dad, don't look.
Dear Lord. But no, you make a very good legal point.
I broke out the wine. I'm not supposed to drink wine, and I haven't been to sleep in God knows how many hours. So
Oh,
good
Lord.
night.
All right. So I will make my point short and sweet. No, I think that you make a very good
Come here,
point.
Roxy.
Is that YouTube doesn't give a damn one way or the other.
Mm-mm.
They don't care. And, you know, look, even though I think, let's take the example of our debate over the recent Florida law. I'll just leave it that way. I thought that was absolutely informative. I think it was useful. I think it was educational. And I think that it complies everything that freedom of use is supposed to uphold.
Except for that first part that I put together.
Right. And, you know,
which is hilarious because I took it from another YouTube channel.
Yeah, and to be honest with you, I didn't care. But it did take me a week and change to get all that clipped out of the video so that I could actually be there again.
It's so stupid.
It's just nonsense. It just is.
But it was a really good video. I spent a lot of time making it pretty.
A good conversation. The video was a great way to introduce the topic. I had no problem with it whatsoever. We talked about it beforehand, so like I'm not just so everyone's.
We
clear,
knew we
I'm
were
not
rolling the
blaming
dice.
Meg at all.
I know I need a bigger shirt. This one's a little tight. I didn't have much in the bucket of shirts. I have mostly kids' shirts. You didn't want to see me in a kid's shirt, trust me.
No comments. But yeah, when it's all said and done, I thought that was an educational, informational video discussing the topic. But I didn't get approval. I still think I'm yellow. I'm like 90% sure. Give me 1 second. Let me double check.
I think you have to take it completely out to not be yellow.
No, because I've gotten emails where they have done manual review and
Oh.
remonetized it. Every single one of my streams. I
Yes,
think
exactly.
what is my record right now?
When you're a small channel, you have to follow the rules so closely and be so careful about what you're doing, which is why it gets so frustrating when everybody's complaining about talking and everything else. Like, I am rolling the dice big time doing just the text only videos, but I can't keep this up every day. I have been
I am
barely surviving as it is. So
92-2.
for how many were demonetized?
So 2 were demonetized, and I understand why, because it related to an officer related deletion.
Officer? I'm confused. I don't know what you're talking about.
Yeah. So because of the violence.
Oh, this is demonetized.
But otherwise, the other 90 were demonetized at the time of the stream. And then they ultimately decided 2 or 3 days later that it was totally okay and under their guidelines.
I have only had two that didn't get approved.
Why
the Judge Dad Marathon?
I do straight streams.
You just
I
do
just
what?
do straight streams. So because mine is constant, because StreamYard.
Well, it's my live streams is what I'm saying that didn't. My regular stuff is all straight approved.
Yeah.
But the live streams, the Judge Dad Marathon and I did some random cases in a therapy session where we just sat and bullshitted for an hour, and that got demonetized. I probably said something bad about YouTube. Who knows? You know, I have no filter.
I think that they really hate that I mention every now and again that if you would like to support intelligent content, I do in fact have a PayPal. JRobinLaw at PayPal. And you don't have to pay the 30% tax that YouTube takes on everything that you send through their platform.
That's why you should just put it on like a sticker on the wall behind you. So you don't have to say it and people can just see it.
Yeah, well.
Penny, what are you doing, honey? Pen.
But no, it is ridiculous the way that they go about doing that.
Did you say hi to everyone? You haven't seen them today.
Yeah, probably.
So, funny story. I'm sitting here on a whatever call with my doctor, psychiatrist, having this really serious, in-depth conversation, and here comes Bull in a china shop, knocking everything over, jumping on my lap, trying to get up and look in the camera.
No.
I was like, oh, so you have dogs? I was like, she's a YouTube whore, just ignore her.
You can't use
He's
that
like,
term
a
anymore.
what?
You can't use that term.
What?
The W1.
That's my dad calling me. That's gonna get me demonetized.
I think the W word started when a certain Suits starlet started becoming popular in social media.
Gotcha.
So ever since then, that phrase has been verboten.
Well, I don't really care.
No, that's fine.
I said it and I relayed what I said. All right, see, well, we got to get out of here because Grandpa's calling. We got to figure out why Grandpa's calling. And then we got to go take our chill out pills. And then we got to go hide under a blanket because it's just about to go down for real.
Well, anybody who does still happen to be here, at about 6 o'clock, I will be going through the Declaration of Independence, word for word. And
word for word.
Are
you gonna wear a hat?
No, probably not. But I will be going through it and showing how that really was the foundation of our Constitution and our Bill of Rights. Was all of the things that we fundamentally were teed off about as they're related to the British Crown. So hopefully that'll be somewhat interesting. If you'd like to see that J. Robine Law over around 6 o'clock.
J. Robine Law.
Yeah, if you want to throw a link into the channel, I don't think I
know. I
can.
gotta find it. Open a tab, find a channel. All right. Everybody have a wonderful evening. Where's YouTube? I don't want to search my channel. I want to find John's channel. Oh, wait. About? You can also go to my About page, and John should be on there under Penny's Best Friends,
There you go.
which won't let me edit. Come on, guys.
Oh, come on. You're expecting YouTube to actually make things convenient?
Oh my gosh, it won't let me edit. It won't let me
That's
get
a
out of
terrible
studio.
mistake.
YouTube. Yes, I want to leave. I want J. Robine Law. Thank you guys for sticking around. I wasn't planning on making this long, but you know, whenever John stops by, you know it's going to be
Yeah, I have a tendency to do that. Sorry.
it's going to be a long one. I like the quickies. John likes to take his time. Yeah, don't even.
Yeah, it's
Just let it
probably
go.
better that I don't.
Yep. Let it go. There is the link to J. Robine Law. Please take a moment and subscribe. Make sure you hit the like button on your way out. Penny would appreciate that as she's choking on her own spit. And Ziggy says, screw y'all. But subscribe, because you know I might be in a good mood at some point in time. One day. Oh, he's in the rainbow bed. He finally gave in. Love it. He hasn't been in that bed. He has danced around it and gone everywhere else but in that bed. Haha, you lost. You get the girly bed. He's not happy. He's got evil eyes. If I ever die, they better find me quick because my animals would eat me.
No, because you have
secretly
dogs.
hate me.
If you had cats, it would be different.
I have 3 cats.
Oh,
They
then
sit and
yeah,
stare at me at night,
They will eat you.
watching. Like, yeah, go ahead, Mom. Eat that other cookie.
See what happens. We'll fall asleep
All right.
after you.
You guys have a great night. Make sure you check out John's stream later. It
All
will
right.
be
Take care, everyone.
amazing.
And Meg, I'll send you the link. You can either, if you want to jump on, great.